I can see their office from my studio window over there at 275 Lawrence. Beautiful building, but I think it's what goes on inside that building that is of the greatest of importance, and it is a collective of lawyers, a team of lawyers who on a daily basis work very hard to make sure that people's lives function and work according to the rules of law in the land that we live. Dealing with the challenges of executor, power of attorney, representative, who to name, and so on and so forth, Colin Flannigan is here. Good morning to you, sir.
Good morning, Phil. Thanks for having me.
You know what? When you sent me the note and said, here's where I'd like to go, I got a great big smile on my face because I know two stories where the choice that they made was abysmal. And it became very complicated in trying to change it later. So what is our starting point for executive power of attorney in a document like a will?
All right. Well, I just want to start by saying why I think this is an important topic to bring up now.
Sure.
When people first come in and do the first estate plan, often one of the first questions is going to be, okay, well, we start to understand what the documents part of the estate plan are. Your will, your power of attorney, your representation agreement. But then the question I often get is, well, who should I name as my executor, as my power of attorney, as my representative?
Your fishing buddy.
Your favorite radio host?
That would work.
So it's an important question that deserves some forethought because there is implications. And if choices sometimes work out the way they didn't work out the way we planned.
Meaning that your life doesn't go the way that you thought it was going to go, and suddenly those documents become eminently important, and the person chosen to execute them becomes even more so.
Exactly. And if we've made a bad choice, it can be difficult to deal with. It can be dealt with, and we'll get into how to deal with that later in the show. But, the way I like to look at it as a part of a planning tool is we want to try to avoid that. So let's start talking a little bit about the documents themselves. And from there, we can get an idea as far as how we should be picking who we want to have these responsibilities.
Done.
Okay. So the first document that most people have heard of is a will. A will governs what happens after we pass away. So in our will, we say, this is who I want to be my executor. These are the powers I want them to have. And this is what I want to happen to my stuff. Now,
and that necessarily doesn't have to be a lawyer, does it?
It doesn't have to be a lawyer, but, the way I look at it is it's a very important document. There is some other qualified people, such as notaries, who can do wills, but when it comes to doing overall estate plan, there's some serious implications as far as getting these documents right.
Right. Okay.
So I think it's more important to look at it and make sure that you're using someone who's good at what they do.
The larger the estate, the more important it becomes.
Exactly. And you can have some notaries that are very good. It's just important same thing with lawyers. You choose someone that is good at what they do and can understand what you want to happen. So from the will, we start looking at, okay, that's nice. That governs what happens after I pass away. The other part of estate planning is what happens when we're still alive. And that's going to be the enduring power of attorney and the representation agreement.
Which means that I had a stroke but didn't die. And I now end up lying in a hospital bed, intubated with tubes running in and out of my body. And who's going to look after me?
Oh, that's certainly a good example. And, to be honest with you, there's sometimes more benign situations where we're just as we get a little bit older, we need some help. And the power of attorney helps when it comes to dealing with financial and legal matters. So someone to help you with your banking, someone to handle managing your affairs. The representation agreement is like the power of attorney, but for healthcare decision-making. So it's going to be who's going to be able to talk to your doctors, give instructions, hire and fire doctors if need be, talk about care plans as we get older and moving into care facilities, and when it comes down to it as well, too, end-of-life decision-making as well.
Often our children, and I only deal from my own point of experience, is that my sister and I both work with the power of attorney for my mother's affairs. We co-sign checks and we handle her day to day, and we make sure that her life is looked after as she spends time in a retirement home over on Vancouver Island. Is it always children, or is it most often children, or what do you do if there aren't children?
Well, it's very fact specific on any given situation. The way I like to look at it is two things. One, it's part of an overall plan, and you got to see how the documents work together, as well as understanding what family dynamics are at play as well, too. Because when we're looking at it, most people think, I want to name a family member. There is also trust companies that will act as executors when it comes to wills.
How about trustee?
Yeah. And then when it comes down to it, though, if we're looking at spouse, children, is this children from that same marriage? Is this a blended family situation? We start dealing with issues of family dynamics, and this is an important consideration. Now, when we're talking about the executor, what we're looking at is going to be someone who's going to be responsible for immediately after the passing, who's going to be able to deal with the funeral home, going to deal with the final remains. So someone that, even despite the immediate moment of deep grief, is going to have that strength to be able to make those immediate decisions. So when you're choosing that person, keep that as a first thought in mind. Second, they're also going to be the one that's going to be responsible for gathering in all of your assets and then making sure that they're distributed accordingly. And even if there's any trust built into your will, is it going to be someone you want to administer that trust? An example I'm going to give on this one is going to be, say, you've got a child that's on provincial disability benefits, and you don't want to have them disentitled because of a gift under the will. So you build in a trust into your will itself, so it's fully discretionary. It's not going to affect their eligibility. So whoever you named as your executor, do you want that same person to be the trustee? And that's a great question. So who is that person? What type of investment knowledge do they have? Are they going to be entitled to hire an investment advisor? What's the relationship between that person and the beneficiaries? Because that executor, they've got a fiduciary duty to those beneficiaries. How well do they get along? Is there a chance for fighting between the beneficiaries and the executor?
Particularly in these times of multiple marriages and blended families and trust, where my initial children by my first marriage, who I really didn't get along with, and then I had a second marriage, and I've had second children that maybe weren't even mine but hers, but I've bonded with her children way more than I bonded with my own. And I see those stories being written about often, and I know a few people that are living it. It gets very complex, and the anger that comes out of it is unbelievable.
Yeah. Legally adopting those second children as well.
There you go. Yeah.
Wills variation issues, how to deal and treat with the different sections fairly. And you got to remember, while you're making these decisions while you're still alive, your executor is also going to be the one that's going to be dealing with these when you pass away. So make that decision, think about it. Who do you want to make these decisions? And a better question then is, there can be situations where we want more than one executor. We were talking, you mentioned about acting with your sister as well, too, jointly as power of attorney. There can be situations where we might want more than one executor. A situation where will it be a little bit easier amongst those family dynamics? How well, if there might be some level of tension between...
How do we soften the division?
Soften the division, soften the relationships between, making it a little bit easier as far as if there's 2 people making the decision, 3 people. One thing to be careful about naming multiple executors, though, is going to be decision-making. Does it have to be unanimous? Because at law, there's a distinction between real property and personal property with decision-making for multiple executors. Do you want to make a clause in your will that says, does it have to be unanimous? Is it a majority rule situation? So that's just some of those thoughts as far as if you do want to name multiple executors, it's not just the relationship between the executors and the beneficiaries, but the executors amongst themselves.
It's big. It's complex. And I don't think very many of us give it the kind of time that it deserves, because most of us have managed to, over time, build very complex lives. With multiple relationships and various children and so on and so forth, and suddenly we find ourselves where we really don't know how to turn. My guest is Colin Flannigan. He is part of the legal team at FH&P Lawyers, talking this morning about who to name as an executor, power of attorney, representative issues. And the one that I want to make sure that we get to before the end of this program, which is, what if the person you picked isn't a good choice? What do you do then? We're going to be back in a moment. Well, I'll tell you what, Colin Flannigan, when you talk about the interrelationship of pieces of paper, when you've got a will and then you have a power of attorney and then you have a representation agreement, and you talk about the necessity of those 3 agreements being knit together to provide, a blankie?
Something to make you feel warm and comfortable.
A cozy, something that you can wrap around yourself to know that you've got a game plan, and to know that the game plan is going to work no matter what misfortune may befall you. It's important.
Absolutely. It's very important. And, there's one thing I just want to mention before we move on from naming executors on wills, before we briefly talk about powers of attorney and representation agreements. Right. It's just residency. So if you are thinking about naming a resident or a executor who's not a resident of Canada, there is implications, both tax related.
Why would you do that?
It happens if you've only got one child and they're living in the United States, as an example.
Okay.
You might have some issues there. That is, if you're thinking about doing that, talk to a professional, because there are serious implications both on the taxation of the estate as well as dealings with any of the assets in the estate, such as a piece of real property and clearance certificates. There is significant issues that could arise. So if you were thinking about it, better to have a lawyer and let that child fly home from the United States to sit in the office as the will is read out. Yeah, it can cause a lot of issues, I'll put it that way. So talk to a professional if you're even thinking about that. Right. In most cases, if we have an executor, isn't it somebody who is known to us and probably lives within the city that we live or in the province that we live? I mean, why would you have an executor? You're living in British Columbia. Why would the executor of your will live in Toronto? An example, unfortunately, sometimes as people get older and we start surviving our friends, our family members, good point. That pool starts to get smaller. Yeah. Or 5, 10, 12 years ago when I asked Billy Bob if he wanted to be the executor or would perform as the executor of my will, he said, absolutely, buddy, no problem. He didn't know at the time that he was going to move to Toronto. And so would you advise that I need to remove him as the executor and find somebody local? I would say talk to your estate planner at that point. Right. Find out what the implications are. Are things still going to work the way you want? Is there going to be logistic issues? Find out if it's still what you want. If that happens, it's easy enough to change if you are still of sound mind. So when it comes to making a change to a will, if you're still of sound mind, you can revoke a will, do a new will. You can do a codicil, just changing a particular clause in your will, say changing your executor provision. When you're still of sound mind, it's easy to deal with. We'll get back to deal with it, what happens after you've passed away, though. Okay. Power of attorney representative. Very quickly. Representative might be someone who has to make end-of-life decision-making. When you're making that decision on who you want to have, keep that in mind. Is it going to be someone that can make that decision and how well that's going to go over with the other family members? Power of attorney. It's really a position of trust, like the representation agreement. What we're talking about is it's someone that's good with money, and what type of powers do you want to put in the power of attorney? An example is going to be certain powers for power of attorney to have to be expressed in the document, such as being able to transfer assets into their own name. Do you have joint assets with that power of attorney already, such as a spouse? Something to keep in mind. So it's part of an overall bigger picture. I'd love to get more in depth, but I really want to move on to dealing with what happens if you've made a bad choice. One quick note I'll put on the table, only because I'm living it. And again, we come back to my sister and I that have a representative agreement for our mother who is in a retirement home. There is a DNR in place. Mm-hmm. But the DNR is very general in its specifications as to what we want to allow happen. That she doesn't go to a hospital, but we ended up in a telephone conference with the retirement home nursing staff to very clearly deliver that if she would contract pneumonia, she is not to be given antibiotics. Mm-hmm. Let the pneumonia take her. If this would happen, she is not. And we basically went through a list and gave them very clear verbal instructions as to what cannot happen with this woman if she gets ill to basically allow pneumonia to do its work. And a well-drafted representation agreement is going to have those express directions as well, too, saying in these circumstances, I would want this treatment, I would not want this treatment. If it's say a terminal condition, a irreversible unconscious state, I would or would not want kidney dialysis. I would or would not want antibiotics. I would or would not want tube feeding. There we go. These are the types of things that are expressed in there that make it a little bit easier for the representative to make that decision because you've already set it out for them. But just bear in mind what's the dynamic between that person and other family members. No kidding. Absolutely. Listen, I appreciate this. So let's get last to the point that we wanted to be sure we touched on. What if you made a bad choice? Okay. If you are still of sound mind, it is easy to make changes.
Right.
Any of these documents can be revoked, and you can name a new one. Just be careful about revoking and not creating a new one, because now you're in a situation where you don't have anything. So sometimes people make that tear through the paper and sort of say, I realize I don't want to give anything to Jimmy anymore. I'm just going to tear my will. Mm-hmm. Well, you did that with the intention of revoking. That will is, no longer will. So when it comes down to it, if you're still of sound mind, you're thinking about making a change, talk to your professional, see if this overall plan still works. If you no longer are of sound mind, let's talk about the power of attorney and the representation agreement. These documents are giving someone power to control your estate as well as the person. The representation being the healthcare decision-making being control of the person. A committeeship can revoke these documents. Now, committeeship is an appointment under the courts by the Patient's Property Act. By the courts under the Patient's Property Act. And what it does is it revokes these documents. It can name someone as committee of the estate and of the person. It's an expensive process, but it can be done. Now, if the person we've named, I'm going to use an example for a power of attorney. Say the person we've named has perhaps made some decisions that the other family members don't agree with, and they start wondering, well, where's this money going? Something's not right here. They can request
Is the individual of sound mind, or have they lost a few? Like, what's going on? Are they being unduly influenced by somebody else?
Exactly. And say the person who granted it has lost capacity. What do you do? Say you think, well, stepbrother Jimmy is taking advantage of Dad here. Dad's no longer got capacity. Dad cannot revoke the power of attorney anymore, but Jimmy's up to something, and I don't like it. Something's not right here. First step, first thing I would suggest is going to be talk to Jimmy. Say, Jimmy, I'd like to see an accounting. Likely Jimmy's going to say no. But when that happens, what you can do is the public guardian trustee can do investigations into powers of attorney. So if someone is abusing a power of attorney, that's a first step to look towards. Okay? If it gets far enough that you need to have it revoked and need an appointment under the Patient's Property Act, then that might be the ultimate end.
Do you have to go to a judge to get that revoked?
Judge or master, if master might be able to make that decision
right.
If it's a uncontested application, but especially in a situation where you are removing a power of attorney and or a representative, it will likely be contested, and you would need to show the reason why this person should be removed. So perhaps some of that information from the investigation. So representation agreement, I would say first thing to do is talk to the representative. If you're worried about some of the decisions being made about the person's care, talk to Interior Health. If you think that nothing is going on, something is getting abused, and you might have to do that committeeship application. When it comes down to the problem executor, can you have an executor removed? Yes, you can. And that's going to be a situation where there is grounds listed under the Wills, Estates, and Succession Act when executor should be removed. And it's worth to consider, is there alternate executors named in the will? Is there co-executors that says if there's more than one executor, the survivor can continue to act alone? These are important questions, especially as it relates to if there's any trust built into the will itself, because then you've got issues of overlapping legislation dealing with the Trustee Act, whether or not a trustee has to be replaced and not just removed. So once again, we're dealing with court applications if we have to fix these errors, which are costly and time-consuming. So when it comes down to it, I made the comment at the beginning of the show, we always look at it, it's better to get the planning right in the first instance.
And make the right choice at the beginning. Very quickly, will you as a lawyer question the names that I'm putting forward as some of those individuals, or do you trust, or do you say, hey, listen, you're the client and this is what you want, or whatever? Or does the lawyer say, I gotta say that as I'm listening to you and as I'm watching what you're putting forward here, I really need to question what you're about here?
I think I'm not doing my job if I'm not having these important conversations.
Okay,
with you.
Thank you. Yeah, okay. I appreciate it, because to me, somebody's got to ask those questions. I'm totally on the emotional headspace long-term friendship side of things, and you are very critically and analytically sitting outside, and so you are able to ask those very hard questions that hopefully will help me drill down and get to the point. Colin Flannigan, always a pleasure. Thank you for being in our studio this morning. You can find, you know what, if this conversation has in any way for any of you caused you to think or rethink or question the will that you may have written, who you have picked to be the executor of, or maybe who you've given power of attorney to, or the representation agreement that will deal with you if something tragic would befall, and you find yourself in a hospital where somebody else is going to have to decide what happens to you. If any of this conversation this morning has resonated, you might want to give them a call at 869-6024. That's 869-6024. Obviously, there's 250 on the front of it. 869-6024. More important, the better thing to do, go to the website, FH&P Lawyers. And once you bring up the website, you'll get the roster of lawyers. Scroll down, you'll find Colin Flannigan. All the connect details will be there. Sir, a pleasure to have you in our studio.
Thank you very much, Phil.
Thank you very much. Looking forward. Next Tuesday, Law Talk with FH&P. Got a couple of minutes to work with in this last half hour. We'll focus in on the American election, take calls, thoughts, what's going on in the United States as Americans by this time tomorrow will be celebrating a president. Is it going to be the first woman president in the history of the United States? Or is it going to be a game show host who will continue to say, "You're fired"?